Attention green card holders across America, a shocking new immigration law has just been approved that will fundamentally change your rights, obligations, and path to citizenship. This is not a rumor or speculation. This is official legislation that takes effect in 2026, and every single green card holder needs to understand what's coming. Stay with us, because what you're about to learn could determine whether you keep your permanent resident status or face serious consequences that could change your life forever. Welcome to US Visa Info, your most trusted source for breaking immigration news, updates, and critical information for anyone navigating the complex United States immigration system. I'm incredibly grateful you're here today because we're covering arguably the most significant immigration law change in decades, one that will impact millions of lawful permanent residents living in the United States right now. We're talking about the newly approved 2026 immigration law that introduces sweeping changes to green card requirements, enforcement mechanisms, and pathways to citizenship. At US Visa Info, we cut through the confusion and political rhetoric to bring you facts, clear explanations, and what changed in the new US immigration law, actionable guidance so you know exactly where you stand and what you need to do. This information is absolutely critical for every green card holder. So let's get straight into what this law means for you. First, let's establish what exactly has been approved. After months of intense debate, political negotiations, and advocacy from multiple sides, Congress has passed and the President has signed into law the Permanent Residence Accountability and Integration Act of 2026, which we'll call the PREA. This legislation represents the most comprehensive overhaul of green card regulations since the Immigration Act of 1990. The stated goals of this law are to ensure that permanent residents are actively integrating into American society, contributing to the economy, maintaining strong ties to the United States, and progressing towards citizenship. However, the practical implications are far more complex and potentially troubling for many green card holders. The first major change under this new law is the introduction of mandatory biennial reporting for all green card holders. Starting January 1st, 2027, every lawful permanent resident must file a status report with USCIS every 2 years. This is completely new and goes far beyond the current requirement to notify USCIS of address changes. The biennial report must include your current address, employment information, tax filing confirmation, any criminal history, including arrests, even if charges were dropped, extended absences from the United States, and information about immediate family members. Failure to file this report on time or filing incomplete or inaccurate information can result in the initiation of removal proceedings. This requirement applies to everyone, whether you've had your green card for 1 year or 30 years, whether you're planning to apply for citizenship soon or not. The reporting system will be entirely electronic through a new USCIS online portal. You'll need to create an account, verify your identity, and submit your report along with supporting documentation. There will be a filing fee currently proposed at $75 per report. Though why green card holders are most affected waivers will be available for those who qualify based on income. The report must be filed within a 30-day window around your designated reporting date, which will be assigned based on when you received your green card. Missing this window without a valid excuse is considered a violation. USCIS estimates that processing these reports will take 60 to 90 days, during which time your green card remains valid. But if problems are identified during the review, you could receive a notice to appear for removal proceedings. The second major change involves physical presence requirements. The new law codifies and strengthens the expectation that permanent residents actually reside permanently in the United States. Under current law, green card holders can face abandonment issues if they're outside the U.S. for extended periods, but the standards have been somewhat ambiguous. The 2026 law establishes clear, bright-line rules. If you're outside the United States for more than 6 months in any 12-month period without obtaining advance permission through a re-entry permit, there's a rebuttable presumption that you've abandoned your residence. If you're absent for more than 1 year, abandonment is presumed and you must overcome a very high burden of proof to retain your status. More significantly, the law introduces a cumulative presence requirement. To maintain your green card, you must be physically present in the United States for at least 6 months out of every 12-month period, and you must maintain an aggregate presence of at least 4 years out of every 5-year period. If you fall below these thresholds, your green card can be revoked unless you can demonstrate extraordinary circumstances such as employment abroad for a U.S. company, military service, or serious family medical emergencies. Simply preferring to live elsewhere or having family abroad is no longer considered sufficient justification for extended absences. The third major change relates to public benefits and public charge. The new law establishes that receiving certain public benefits for more than 12 cumulative months during your time as a green card holder can result in your status being reviewed and potentially revoked. The benefits included in this new rules, restrictions, and compliance checks calculation are SNAP food assistance, Medicaid except for emergency services, SSI supplemental security income, TNF cash assistance, and federally subsidized housing. If you've received any combination of these benefits for 12 months or more, USCIS can initiate proceedings to terminate your permanent residence on public charge grounds unless you can prove that your circumstances have changed and you're no longer likely to become primarily dependent on government assistance. This provision has generated enormous controversy because it essentially creates a retroactive public charge test. Many green card holders legally accessed benefits they were entitled to, particularly during the COVID-19 pandemic or during periods of job loss, and now they could face consequences for having done so. Elderly green card holders who receive SSI or Medicaid are particularly vulnerable. Advocates argue this violates due process and fundamental fairness, but the law has been written to withstand constitutional challenges, at least according to its drafters. The fourth significant change involves employment requirements and economic contribution. The new law states that permanent residents must demonstrate ongoing economic self-sufficiency. Specifically, if you're of working age defined as between 18 and 65 and you're not employed or engaged in educational activities for more than 18 months within any 3-year period, you must demonstrate that you have sufficient assets or other lawful means of support. If you cannot, your permanent resident status can be reviewed. There are exceptions for individuals who are disabled, serving as full-time caregivers for family members, or facing documented barriers to employment, but you must proactively document and prove these exceptions. Additionally, the law requires that all green card holders file U.S. tax returns reporting worldwide income even if no tax is due. Failure to file taxes for any year during your permanent residence can be grounds for status revocation. This has always been a requirement, but it was rarely enforced. Now, USCIS will be cross-checking with the IRS, and missing tax returns will be flagged during your biennial report. If you've been a green card holder for years and haven't filed what this means for travel and reentry taxes, you need to get into compliance immediately. The IRS has streamlined procedures for delinquent filers, and while you may face penalties and interest, getting current is far better than losing your green card. The fifth major change concerns criminal issues and moral character. The new law significantly expands the types of criminal conduct that can result in green card revocation. Previously, only certain serious crimes, particularly aggravated felonies and crimes of moral turpitude, could lead to deportation. The 2026 law adds new categories, including multiple DUIs, domestic violence misdemeanors, drug possession offenses, even at the misdemeanor level, fraud or theft offenses, regardless of sentence, and any crime involving dishonesty. Even if you received deferred adjudication, probation, or your record was expuned under state law, USCIS can still consider these offenses when evaluating your continued eligibility for permanent residence. Moreover, the law introduces a conduct-based review beyond criminal convictions. If USCIS receives credible information that you've engaged in conduct that demonstrates a lack of good moral character, such as fraud in obtaining benefits, tax evasion, or other dishonest behavior, they can initiate removal proceedings even without a criminal conviction. The standard of proof is civil, not criminal, meaning USCIS only needs to show by a preponderance of the evidence that you engaged in disqualifying conduct. The sixth change relates to family-based obligations. The new law requires green card holders who obtain their status through family sponsorship to demonstrate that they maintaining the family relationship that formed the basis for their immigration, at least for the first 5 years. If you obtained your green card through marriage and you divorce or separate within 5 years, USCIS will presume that the marriage was fraudulent unless you can overcome this presumption with substantial evidence. Similarly, if you obtained your green card through a parent, adult child, or sibling and you completely sever the relationship within 5 years, this can trigger a review. The law is attempting to crack down on immigration fraud, but it also intrudes into private family matters in ways that visa and status risks you must know many find deeply problematic. The seventh major change involves the path to citizenship. The new law maintains the basic requirement that you must be a permanent resident for 5 years before applying for naturalization, or 3 years if you obtained your green card through marriage to a U.S. citizen. However, it adds new hurdles. First, you must have filed all required biennial reports and have had them approved without significant issues. Second, you must demonstrate continuous physical presence as defined by the new standards. Third, you must pass an enhanced civics examination that includes more detailed questions about U.S. history, government, and civic responsibilities. Fourth, you must demonstrate English proficiency at a higher level than before, including reading, writing, and speaking. Most controversially, the law introduces a new requirement that naturalization applicants must demonstrate integration into American society. This includes evidence of community involvement such as volunteering, membership in civic organizations, participation in local activities, knowledge of local history and current events, and understanding of American cultural norms and values. Critics argue this is subjective and potentially discriminatory, favoring applicants from certain backgrounds over others. Supporters argue it ensures that new citizens are truly committed to and integrated into American life. Regardless of your view, This requirement will make naturalization more difficult and more expensive as applicants gather evidence to satisfy these subjective criteria. The eighth change involves enforcement and consequences. The new law allocates substantial resources to USCIS and ICE specifically for enforcement against permanent residents who violate the new requirements. This means more investigations, more home visits, more audits of records, and more removal proceedings. ICE will have expanded authority to detain permanent residents during removal proceedings, particularly those with criminal histories or those deemed flight risks. The standards for bond and release will be stricter. Permanent residents facing removal will find it harder to fight their cases because many of the new grounds for removal are not subject to the same forms of relief that were previously available. Additionally, the law creates mistakes that could put your green card at risk new penalties for those who help permanent residents evade these requirements. Immigration attorneys, notarios, and others who knowingly assist someone in filing fraudulent biennial reports or hiding disqualifying information can face criminal prosecution and civil penalties. This is intended to prevent fraud, but it also creates a chilling effect where some practitioners may be hesitant to help complicated cases for fear of liability. Now, let's talk about what these changes mean for different categories of green card holders. If you're a recent green card holder who received your status within the last year or two, you need to understand that the rules have changed significantly from when you applied. Make sure you're tracking your physical presence carefully. Set up a system to document your days in the United States. Keep records of employment, tax filings, and any benefits received. Start preparing now for your first biennial report, even though it's not due until 2027. The more organized you are, the easier the process will be. If you're a long-term green card holder who's been in the United States for many years but hasn't applied for citizenship, you need to evaluate your situation carefully. If you meet the requirements for naturalization, this may be the time to apply. As a U.S. citizen, you'll be protected from these new requirements and enforcement actions. Citizenship provides security that permanent residence no longer offers. However, if you have issues in your background, such as criminal history, unfiled taxes, or extended absences from the U.S., you need to consult with an immigration attorney before applying for citizenship, because the naturalization process will scrutinize your entire history as a permanent resident. If you're a green card holder who travels frequently for work or family reasons, the new physical presence requirements may create serious problems for you. You need to track your absences meticulously and consider whether you need to make changes to your travel patterns. If your job requires extended international travel, talk to your employer about whether they can provide documentation supporting that the travel is for their benefit. Consider applying for a re-entry permit if you anticipate being outside the U.S. for more than 6 months. Though, understand that a re-entry permit doesn't exempt you from the physical presence calculations for maintaining your green card long-term. If you're an elderly green card holder who receives SSI or Medicaid, you're in a particularly vulnerable position. The What Green Card Holders Should Do Now, public benefits provisions of this law could put your status at risk. You need to consult with both an immigration attorney and a benefits specialist to understand your options. In some cases, it may be advisable to apply for naturalization if you're eligible. In other cases, you may need to transition to benefits that aren't counted under the new law or explore other options for support. If you're a green card holder with any criminal history, even minor offenses that you thought were resolved, you need to get a complete copy of your criminal record and have it reviewed by an immigration attorney. Many offenses that didn't trigger immigration consequences before could now be grounds for removal. You may have options to expunge, seal, or modify your convictions under state law, which could help your immigration situation. Don't wait until USCIS initiates removal proceedings. Be proactive now. So what should every green card holder do immediately? First, gather and organize all your immigration documents, including your passport, green card, approval notices, and any correspondence from USCIS. Second, get copies of all your tax returns for every year you've been a permanent resident. If you're missing any, file them immediately. Third, create a physical presence tracker and reconstruct your travel history as accurately as possible. Fourth, review your criminal history, if any, and consult an attorney if you have any concerns. Fifth, evaluate your eligibility for naturalization and consider applying if you qualify. Sixth, register for the new USCIS online portal when it becomes available and mark your biennial reporting deadline on your calendar with reminders. Seventh, consult with a qualified immigration attorney who's familiar with the new law to assess your individual situation and develop a strategy. It's also critical to stay informed as regulations and guidance are issued. The 2026 law establishes the broad final summary and key takeaways framework, but many details will be filled in through regulations that USCIS will publish over the coming months. These regulations will clarify ambiguities, establish procedures, and provide guidance on how various provisions will be implemented. Subscribe to USCIS email updates. Follow reputable immigration law sources and stay connected with channels like US Visa Info that will keep you updated on developments. That brings us to the end of today's critical breakdown of the shocking new US immigration law approved for 2026 here at US Visa Info. I hope this comprehensive overview has given you a clear understanding of what's changed, how it affects you, and what steps you need to take to protect your status. This law represents a fundamental shift in how the United States treats permanent residents, moving from a relatively hands-off approach to active monitoring and enforcement. Whether you view these changes as necessary accountability measures or as unfair targeting of immigrants, the reality is that they are now law and you must comply. If you found this video essential, please give it a thumbs up and subscribe to US Visa Info so you never miss critical immigration updates. Hit that notification bell because we'll be posting follow-up videos as regulations are issued and as we learn more about how this law is being implemented. Share this video with every green card holder you know because millions of people are unaware of these changes and everyone needs this information. Do you have questions about how this new law affects your specific situation? Drop them in the comments below and I'll do my best to provide guidance. Though please understand I cannot give personal legal advice. What I can do is point you toward resources and general information. Also, let me know what aspects of this law you'd like us to explore in more depth in future videos. Thank you so much for watching US Visa Info. Remember that knowledge is power, especially in immigration matters. Stay informed, stay compliant, take proactive steps to protect your status, and don't hesitate to seek professional legal help if you have concerns. Your life in America matters, and we're here to help you navigate these challenging changes. Stay strong, stay informed, and we'll see you in the next video right here at US Visa Info.